in the next 10 minutes, I'd like you to get an answer to one question, which is, what's behind holdup? So for that, I'll very briefly go through, how everyone has been defining holdup. I'll go into, is the market conducive to this effect? And then I'll go into what's really behind this debate. So we've listened, and I think the previous panelists have eloquently defined what holdup consists. Is you sort of get your IP included in a standard setting organization. You wait for that to happen, and then once that's in, you go to a licensee and you say, well, here's my royalty, which is much higher than you ever thought, and then you charge a price that is above what the value of your IP. In essence, it's an exploitative conduct, okay, as opposed to exclusionary conduct from an antitrust perspective. So I guess the first question one should ask is this really happening? Okay, and Steve has made, I think, a very good case why there is no economic evidence to support the case for a systematic problem. I guess the idea that I would like to add now is do we see that this is some of these standard setting organizations are conducive to this conduct, and there are three elements that in isolation and in combination I think are very important to understand whether this is a real problem. The first is a lot of the disclosure that happens within standard setting organizations happen before the standard is adopted. In other words, many licensees know what they're getting themselves into. There is the ex-ante disclosure, for which many people within the standard setting organizations have advocated for. To give you an example, in 4G, I think most of the companies that were contributing significantly to that standard disclosed the terms of their license before the standard was adopted. So that alone undermines the case that there is some form of deception, or that they're surprised when somebody comes in with a royalty that is higher than they originally thought. The second element is FRAND, or standard essential patent, does not automatically mean that you have market power. And this is a myth that I keep hearing again and again and again. A FRAND commitment is enforceable in court. So if you're not happy as a licensee with the terms that you're getting, you can go to court. That has always been possible. The number of injunctions, contrary to what popular belief, the number of injunctions that patentees are getting is incredibly low. I dare you to find anyone in the US. I think there's been very, very few. The recent case from Huawei ZTE adds another layer of protection to those that thought that still that was a problem. So all in all, I think that before we have to be very careful before assuming that because you have a standard essential patent that you have market power. The third component is, even if you don't think that patentees are going to do the right thing, you can at the very least trust them that they're not going to do something that is against their interest. And that has to do with many of the patentees in the standard setting organizations have a lot of skin in the game. In other words, if you charge very high prices and get too greedy, that's going to result in the standard not being adopted, not being successful. You lose from that. You don't win when that happens. And that is certainly specific in the case of Qualcomm. We are in this debate one of the very few companies that sits on both sides of the fence. And that's a point that you don't hear a lot. So there are a few companies that derive revenue from licensing, but also derive revenue from making things. 2/3 of our revenue are related to the chipsets we sell, which of course practice the IP included in these standards. So I guess and that takes me to my next point. If the evidence on holdup is so weak, if there is no case, then why is this such a hot topic? Why are we here? And let me tell you where all this is going to, what's behind hold up. And it's this thing called smallest sellable patent practice unit. So those that are advocating in favor of hold up are going a step farther and are saying, because prices are excessive, you need to charge your royalties, you need to calculate your royalties not in relation to the end device, but in relation to the smallest sellable patent practice unit. So to give you an example, that means that if you have a patent that reads on a phone, you cannot calculate that on the basis of this, but on the basis of the chipset. So let's take GPS as an example. Most of you probably have a smartphone. You use GPS connection, for example, for navigation, for turn-by-turn navigation. For your phone to be located by a GPS, that would take anything between 3 or 4 minutes, which will substantially undermine your phone experience. You will not be able to find a restaurant nearby. You would not be able to get locations within time. There is a patent that uses the cell network to locate your phone, lock that phone with a certain number of satellites, so you can do that very, very quickly. According to proponents of this SSPPU, you should calculate the value of that patent in relation to the value of the chipset. Now, if you're thinking, but wait a minute, why does it matter? It doesn't matter that, well, the idea behind it is the following. There's a psychological effect that you would not be able to obtain as much royalty, because it's a lot harder for you to say, well, the value of my IP portfolio is 300% of the value of the component. And this is what this is all about. And if you're thinking, but that's technical nonsense, it is. In the example of the GPS, even if you license the component manufacturer, there's still a patent claim that reads on the phone and a patent claim that reads on the network, on the cell network. So that would open a can of worms that is, in my mind, certainly not pro-competitive and conducive to innovation. So at this basis, what is behind hold up, what is behind excessive pricing, is nothing more than an attempt to shift bargaining power from an innovator to an implementer, thinking that that would have no effect on innovation. I think that is fundamentally wrong. I think that if you're asking, but wait a minute, does that apply for every market? No. And Hugues will talk now about licensing in the next generation or Internet of Things. Of course, if you have a car, you're not going to license your IP when you're just providing limited functionality in relation to navigation. And you need to calculate your royalties in relation to the communication module of that car. So there is common sense in this approach. But I will conclude with this, what I want to make sure that everyone understands is that this hold up debate, it's the facade of an underlying movement, if you want to call it, that seeks to shift the bargaining power within standard setting organizations. I don't think that would be good for innovation. As an antitrust lawyer, I think from an antitrust policy perspective, I think one has to be very careful before lending your support to that theory. Thank you very much.